Okay. Hi guys. Hi guys. Good afternoon. You know, uh, so welcome to our BCCA classes, law classes. So, how are you? I think everyone are fine. Anyone? Okay. Hope you all guys are doing good. Nice. Very nice. So, so what else? Okay. So let's start the session. Okay. So, in the last two sessions, we discussed about exam paper pattern and what is meant by law and what are the topics which we discussed in our law, right? So we discussed pretty much, okay, but we have not, we did not go into the depth of law. We did not even start our classes. We've just discussed about the overview of the subject overview of the subject, right? So we've discussed what have we discussed yesterday. Okay, what did we discuss yesterday? We discussed about business law, right? Business law means it is nothing but solution for a problem. Business law means it is nothing but solution for business problems, right? So we heard that law means it is a solution for problem, right? It is solution for problem. So okay, law is a solution for a problem. It's very good, very fine, and there is no doubt about it. Now, in today's session, we are going to discuss about the sources of law. I mean, how law is made, what are the sources, from what sources the law is being interpreted or the law is being made. That is a topic which we are going to discuss today. Okay, so it is given in our syllabus, it is also given in our subject. Okay, it is also given in our syllabus. So let us go to chapter 1, unit 2. Okay, chapter 1, unit 2. We'll discuss unit 1 later. Okay, right now, in the last session, we discussed about law. In this session, we are going to discuss the sources of law. That means, what are the sources which are taken to interpret the law or to make the law or to uh, to uh, to to implement the law. Okay, so we are going to discuss about the sources of law. Okay, you get my point? So today we are going to discuss about the sources of law. See, what are the sources of law? Okay, so what are the sources of law? See, law makers have identified three sources of law. They they interpret or they bring new laws by basing upon three situations or three sources. What are those sources, sir? You may ask me. Okay, you may ask me that what are the sources for us to bring into force the law, okay, to interpret the law. Okay, so these are the three sources to make law. Okay, so first source is nothing but it is from customs. Second source, it is judicial precedent, and the third source is legislation. First source is what, my dear students? It is from customs. Second source, it is from judicial precedent, and third source, it is from legislation. Did you get my point? So first we'll discuss about custom. See, based upon customs also, lawmakers, they make laws. Okay, they make laws. Sir, how can lawmakers, I mean, how can law be made by basing upon customs? Right? What is mean by customs? Yeah, you may be asking me like that. I'll just give you a small example, right? See, customs are nothing but the things or the values or the important points which are being influenced from past itself in the society. Okay, so which are being followed from long ago itself. Okay, not just right now. Okay, not basing upon the situations which are faced right now, but basing upon the situations and basing upon the solutions from past long years ago. Okay, so customs are what, my dear students? These are observed continuously for a long period, long time without interruptions. Without interruptions. Not just for, not just before 1 year or not just before 2 years. It has been in practice in the society since long. Since it is an antique piece. It is an antique. So, how can you say that, sir? How can people follow customs? How can people follow customs and make laws? See, I'll just give you a small example. So in the marriage, people hold. People hold their hands one upon another, and they walk. They walk, right? They walk 7 times. No, they walk 7 times. How did it come from? From 10 years? From 15 years? From 20 years? No, it has been in our tradition since long, right? How can you say, sir, this come into our society from 5 years? How you can say that like that? No. So we don't know from which time it has come into our society, but we follow that. So customs are the things which we follow right now from long period. Okay, so law we are also framed basing upon the customs. Sir, what are the steps? What are the tests? Okay, what are the tests for us to understand that the customs are made by law, by from many years? Do we need to follow the customs? Do we need to follow the laws which are being provided in the since long time? Is it necessary for us? Is it necessary for us to follow those principles and prepare the law? Yes, my dear students. If it is moral, if it is moral, those customs, if the customs and traditions are moral, then there is no doubt about it to follow. But if customs are immoral, then there is no need for us to follow those. Can you give me a small example? Yes, I can provide you a small example. You can take a child marriage as an example, right? Child marriage. Do you know about Sati Sagamana, right? So it is, the wife, this wife has to die along with the husband. Okay, so Sati means what? Sati Sagamana means what? Wife, if the husband is dead, so wife also has to die along with the husband. They used to burn the wife along with the husband so that they may meet in heaven. They used to think like that. Is it moral? Sir, it is being followed from since long time. Yes, it's being followed from since long time. But is it moral? It's not moral. It is immoral. So, the lawmakers, before interpreting the law, before they interpreting the topics, before interpreting the law, the solutions into the society, what they see is since long time what is being practiced, and that practice, is it ethical, is it moral or not? See, Sati Sagamnam is not moral, child marriage is not moral, Devadasi concept is not moral, but those days people, they used to follow, right? If they used to follow, there is no need for us to follow right now because it's not moral. So before following and before interpreting the law, the lawmakers, what they see is it moral or? So the customs, yeah, they may make the law based upon the customs, but what is the thing which they have to they keep in mind is they feel the moral aspects. They take only the moral aspects, not the immoral aspects. See, this is one of the tests This is one of the test of customs. See, they take only the moral aspects since long time. What is being practiced in the society since a long time? They take only the moral concepts. Point number two: this this customs has to be in practice since long. I said no. It has been in practice since long time, right? So it have to be in practice from a many long years. From a many long years. And I already told you that. Do you know from which time did it start? Did it start from 5 years? Did it start from 10 years? Did it start from 20 years? No, it is immemorial. The time is not memorable. Okay, we cannot decide that from where this law has been influenced, from where this law has been taken into force. We cannot take that into consideration. Okay, so while practicing the customs, it has to be moral. Point number two, it has to be in continuous practice. Point number three, it have to be from the time immemorial. That is, it have to be antique. We don't know from where and from which time it started, but it is being practiced in the society, right? So that is the custom. So lawmakers, what they do is they make the law by taking customs also as a base, by taking custom as also a source. While taking custom as a source, they also have to put in mind four things. That what? Point number one, it has to be followed since long time immemorial. It has to be continuous practice. Point number three, it has to be moral. It has to be moral. And last and most foremost point it has to be reasonable. It has to be reasonable. Did you get my point, students? Are there any doubts? So customs. Did you get my point? So the jurists and courts have laid some essential tests for customs to be recognized as valid sources of law. What are those two tests? One is antiquity. The second one is continuous practice. Third one is what? Third one is reasonableness. And fourth one is morality. Fourth one is morality. Point number one, first one is antiquity. Antiquity means it has to be in practice since immemorial, time immemorial. It has to be now also in continuous process, practice. Point number three, it has to be in a reasonable way and not, it has to be based upon rationality and based upon reasonableness. Last and foremost point, it has to be moral. It has to be moral. Did you get my point? Did you get my point? Yes, it has to be in practice. But just being practice is not important. Morality must be most important perspective. Based upon all these things, lawmakers, they make the law. They provide us the law. Do you get my point? So next. So the next point is that, so what are the types of customs? What are the types of customs? What are the types of customs? Let's have a quick points. There are 3 points. Okay. Point number one is there are 3 types of customs. 3 types of customs. One is general customs. Okay. Point number 2 is local customs, and point number 3 is conventional customs. Point number 1, general customs. Point number 2 is local custom, and point number 3 is conventional customs. So now we have to understand what these 3 types of customs are. What these 3 types of customs mean. Okay, so let's start. Okay, there are 3 types of customs. One, general custom, right? General custom is nothing but these are the customs when they are prevailing to the entire country. Entire country, they follow. Those types of customs are called as general customs. Those types of contractors are customs are called as general customs. No, not the entire country, but when it is applicable only to the part of a state or to the particular region of a country, then those types of customs are called as local customs. Those type of customs are called as local customs. Sir, now my point is, we as human beings, we also deal with many people, right? With many people, we also talk with many people, we also make contracts with many people, right? So based upon our business, to expand our business also. So, so in order to make laws based upon those customs, based upon those practice, what are the customs? Is it general? No. Is it local? No. What type of custom is it? Those customs which are related to trade are called as conventional customs. Are called as conventional customs. Conventional customs means these are the customs when two or more people enter into an agreement related to trade. Related to, so point number one, there are three types of customs, right? One is general custom. General custom is applicable to entire country. Entire country. Point number two is local custom. Local custom is not applicable to the entire country, just applicable to one state or one particular religion. Whereas conventional customs are those customs which two or more persons, what they do, they enter into an agreement in order to what? To expand their business, or which are related to the trade. Those types of businesses are called as conventional, sorry, those types of customs are called as conventional customs. So are there any doubts regarding the customs, my dear students? Yes. Are there any doubts regarding to the customs? Okay, so by basing upon the customs also, lawmakers, what they do is they prepare what? They prepare, they make law. So that in the last class, law is a solution for a problem. So in order to bring the solution to the society, lawmakers, how they bring the solution, first they look at customs. First, they look at customs. In this, this problem is have this problem already existed before? If at all, if that problem would have existed at that time, what would be the solution at that time? So first, they look into the history. Okay, they look into the history, the custom. How did they give the solution? Based upon that, lawmakers now also they give the solution based upon the custom. So custom have to be four things: reasonable. Custom have to be from a continuous practice. Custom have to be from where? Continuous practice since long time, which is immemorial. Immemorial. And last and foremost thing, customs have to be what, my dear students? Moral. Customs have to be moral. So, did you get my point? So, are there any doubts regarding this? So, what are the sources of law? There are three sources of law, and one among them is customs. One among them is customs. So, before going into the second topic, just have a small reading. Okay, just read it. Just go through this. Okay, we'll start the second topic. Second topic, which is called a judicial precedent. Okay, before going into that, just have a small reading based upon the topic. Okay, please go through that topic. So, guys, are there any doubts, online viewers? So, what else? I think you guys have understood this topic. Okay, so I think you've gone through the topic. So let's go to the second topic. The second major source of law. What is the second major source of law? Is judicial precedent. Is what, my dear students? It is judicial precedent. If we've discussed till now that the lawmakers before making a law, what they do, they based upon three sources, they prepare the law, they make the law. Okay, so first one is custom, the second one is judicial precedent. Judicial precedent. Sir, what is mean by judicial precedent? What is mean by judicial precedent? You may ask me that thing, right? See, judicial wisdom is nothing but the judgments which are previously being decided in the courts. Okay, the judgments which are previously decided in the courts. Based upon those judgments, also lawmakers, if they prepare law, if they make law, that type of source is called as judicial precedent. So point number, we know that there are three types of courts, right? We've already discussed about these things, in our foundation topic, right? In our foundation, the introduction of law, there we have discussed many things, right? So I'll just give a small description. There are three types of courts. One is Supreme Court, the second one is High Court, and the third one is Lower Court. Right? The Supreme Court has the highest power, right? Highest power. See, if a judgment is passed in the Supreme Court, if a judgment is being passed in the Supreme Court, that judgment has to be followed by the remaining subordinate courts. Am I right or not? Am I right or not? The lower courts has to follow what the upper court have decided. The upper courts judge based upon the upper court judgment only. The remaining courts, the subordinate courts have to be followed. Right. So Supreme Court has the highest authority. So the judgment which are passed the Supreme Court, or the judgment which is passed in the courts, have to be followed by we'll discuss about judicial wisdom. See, the judicial decisions can be divided into two parts. One is ratio decidendi, the second one obiter dicta. There may be a chance of asking about these two topics, my dear students. Just analyze it. Just keep a keen observation about these two topics. What is meant by ratio decidendi and obiter dicta? Ratio decidendi is nothing but if at all a judgment is passed in the court, if at all the judgment is passed in the court, the judgment is passed in the court, it is binding in the future cases involving similar questions of law. If the same situation arises in future also, the future courts or the future judges has to follow the decision which is passed right now. So this case decision, if at all the same similar case would arise in the future, in that case, that situation, that solution has to be provided only basing upon this judgment. Do you get my point? If at all in future case would arise, that case have to be taken, the decision or judgment have to be taken by taking base as right now today's decision. So this decision or this judgment shall be applicable if the same or similar case arises in future also. So that type of decisions are called as ratio decidendi. Ratio decidendi means it is a reason for the decision which is forming part of the judgment. It is binding in future cases involving similar questions of law. It is considered as a general principle which is deducted by the courts from the facts of the particular. The second one is obiter dicta. It is obiter dicta. Sir, what is meant by obiter dicta? Obiter dicta. What is meant by obiter dicta? Obiter dicta is entirely different from ratio precedent. Obiter dicta. What is meant by obiter dicta is, see, if at all a case arises right now, and if at all in future someday case arises in the future, the same and similar case arises in future. Okay, if at all the case arises in 2014, sorry, in the year 2014, a case arises, and the same case arises on 2024 also. So, obiter dicta means the judgment which is given in the year 2014, if at all this court, if at all this judge, if he wants to take, he can take. If he doesn't want to take, he cannot take. It's his wish. So those types of things are called as obiter dicta. The judgments are called as obiter dicta. Is an opinion expressed by the judge orally or in the judgment, and it lacks a legal conviction. It is relevant only as an illustration and has got only persuasive value of for the lower courts. But whereas this is mandatory if that situation arises in future also. All the courts have to follow. Those type of decisions are called as ratio precedent. Ratio precedent. Did you get my point, my dear students? Did you get my point? So the decisions which are given in the courts, those also based upon those decisions, also based upon those judgment, also lawmakers can make the law, can prepare the law. Okay. So point number one, based upon the situations which are arising in the past, or from continuous which are being in practice since a long time, based upon those things also lawmakers can make the law. Second point is based upon the judgment which are being faced in the courts also. Based upon those judgments also, lawmakers, what they can do, my dear students, they can make the law. Okay, so these decisions or these judgments are of two types. One is ratio precedent, the second one obiter dicta. Ratio precedent means if a similar case arises in future, the similar case, if it arises in the future, then do one thing: go and refer the case which is arised in past. Based upon that, give the solution. That is mean by ratio precedent. In obiter dicta, if at all similar case arises in the future, then do one thing. If at all you want to take the same judgment as happened in the past, take it, or else you can take your own decision. That is the judgments which are for obiter dicta. Am I right? Okay, is it okay? You get my point? So we'll just go through the courts, different types of courts. Let's go to the courts. Point number one, judicial precedent. What is meant by judicial precedent? In simple words, judicial precedent refers to a previously decided judgments of a superior courts, such as higher courts and supreme courts, which judges are bound to follow. Point number two. First, what is meant by Supreme Court and what is meant by High Court? What is meant by Supreme Court? Supreme Court, it is a supreme judicial authority and a streamlined system of courts. It has supreme power. It has supreme power. It binds all the courts in India. Not bound by its own decisions or decisions of Privy Council or Federal. Okay. Then what about High Court? High Court is binding on all courts within its jurisdiction, within its boundaries. It binds all the courts within its jurisdiction. But whereas Supreme Court binds all the courts, not based upon jurisdiction. Okay. Did you get my points, my dear friends? Okay. Point number one, Supreme Court we've discussed. Point number two, High Court also we've discussed. And see, let's understand. In case of conflict with decisions of same court and bench of equal strength refer to a higher bench. Decisions of Privy Council and Federal Court are binding as long as they do not conflict with the decisions of Supreme. See, if at all there is a difference, then those decisions should not be against, should not be against Supreme Court. And the lower court, let's go to the lower court also. Bound to follow, lower courts are always bound to follow decisions of high courts in its own state, in preference to high courts of other states. So in detail, okay, detail from today's lesson, from today's session, I can tell you two things that we discussed. Major sources of law, right? Sources of law. In that sources, we discussed two topics. See, how can lawmakers implement, or how can lawmakers make the law? When they can make the law based upon three things. But today we have discussed two things. Point number one, from the customs, and point number two is nothing but from the judicial wisdom. Customs are being followed from the continuously from in practice from long time, right? But if it is moral only, we have to take it into consideration. Point number three, it has to be reasonable. Point number four, it has to be from a antique, from a time which is immemorable, Point number two is judicial precedent. Judicial precedent means the lawmakers take the law or prepare the law or make the law based upon the judgments which are given in the based upon the judgments which are given in the you get my point? Okay, so these decisions are of two types. One is res judicata and second one is vita dicta. Or res judicata means the decisions or the judgments which are given in past shall be bound in future also. That decisions and that judgment, if at all the similar case arises, when there is no need to follow the same judgment which is given in the past, those type of judicial decisions are called as vita dicta. So with this, we'll conclude the session, and we'll discuss the remaining topics in our next session. The remaining topic is, law can be made by way of legislation. It is most important, my dear students. Don't skip tomorrow's session. Okay, be regular. Okay, so till now, what and all we discussed, just go through the topic. Okay, just go through the topic so that you may get a detailed understanding. From my perspective, actually, this topic is given by the institute just for our understanding. From exam-oriented examination perspective, it is not relevant. It is not more important, but you should have understanding, basic understanding, right? How is the law made? How the lawmakers prepare or make law? So that is the reason Institute has given this unit for us to study. So go through the topic once, okay? And if at all you have any doubts, we'll discuss in tomorrow's session. Okay? Take care. Bye bye. Signing off. Bye bye.